Okay, so now we're going to continue on with the lecture, but this time I'm actually going to show you what it is I normally do here. This is obviously my laptop. I'm in my office. There's my office. I hope you didn't get dizzy there. Anyway, so this is all I do is I'm just watching myself. Usually I have the lecture notes here. And so, but right now I actually have them taped on the glass up here so that I can see them to make sure I hit all the points. So let's continue on with the bureaucracy, with the judiciary. So we're going to be talking about, the next thing we're going to be talking about are other kinds of cases that can be appealed to the Supreme Court. We talked about federal cases already. Now we're going to talk about other cases that can be appealed to the Supreme Court. The other kind of cases that can be appealed to the Supreme Court are ones that come through the state court system, right? We have state courts, we have federal courts, and if you have a defendant in a case in the state court, it means that they've broken a state law. If they get convicted, they're going to go to a state prison. And the state courts have basically the same process that the federal courts have. There's a lower court, there's a court of appeals, and then there's a Supreme Court. So if you're convicted in a lower court, at state court, and then you go ahead and you appeal your way all the way up, and it's the same process. When you appeal, you can't appeal on the basis just of the evidence. You can't say, oh, these guys are idiots. They didn't understand the case. Let me show it to you. You have to go ahead and demonstrate that you have, that there was some sort of problem with the process. In any case, you can go from the lower courts to the Court of Appeals to the state Supreme Court, and you can go from the state Supreme Court to the United States Supreme Court. So you can appeal from the state Supreme Court to the United States Supreme Court. And keep in mind that hope you're not getting dizzy here, I should try and stand still. Every state has its own state Supreme Court. And so that's the idea behind that. So there is a way to go from the state to the U.S. Supreme Court. But the court will only take the case if there is a federal issue involved. If there's something that has to do with either federal law or constitutional law. So for example, there's a very famous case where a guy was tried and convicted of a misdemeanor. I think it was in Florida. And he wasn't given an attorney because back then you didn't get to have an attorney. And so the idea was that he sued saying the Constitution protects my rights. And one of the things it protects me is that I have a right to representation. I have a right to an attorney. And so he was arrested in the state. He was convicted in the state. But eventually that went to the Supreme Court, and the Supreme Court ruled this was a federal issue. There was a federal issue involved here, whether or not his civil rights were denied him. So that's the way it works. Now, the process by going ahead and having a case reviewed at the federal level, it starts off in the U.S. District Court, a U.S. Federal District Court. And there's a link on there. Actually, I could probably, no, I can't. There's a link on your lecture notes, and you can go ahead and you can click on it, and it'll appear, and you'll see a drawing of the federal court system. So go ahead and pause me right now, and then go ahead and click on it. And then you'll see this map. Did you do it? Okay. Now, while you're looking at the map, just go ahead and listen. As you can see, it's divided up into sort of different colors. Notice that every single state, like we'll look at California first. See how California, where there's those 4 little sections? There's 4 little sections there. Each one of those represents a U.S. District Court area. There's a U.S. District Court in each of those regions, right? And so California has 4. But if you look in Wyoming, Wyoming only has 1. For some reason, Oklahoma has 3. You can see there's a little squiggly lines, and there's 3 different areas. But every state has at least 1 federal district court, right? And that's where most cases are tried. If a defendant breaks a federal law, they're going to go ahead and they're going to go to a federal court. And so that's the first thing that you should see, is that every state has at least one federal district court. And most cases, when they start there, that's where they end. Just because if you're a defendant and you don't like the decision that you got in the district court, that doesn't mean that you automatically get to appeal and everybody gets to go up to the next level if you don't like what happened. Not everybody gets to appeal. But if you go ahead and let's say you're convicted in the federal courts, what can happen is then you go ahead and you appeal, and let's say the U.S. Court of Appeals accepts the appeal. They agree to hear your case. In a case like that, what the Court of Appeals is going to do is they're going to review the decisions of the U.S. district courts. What they're not going to let you do is retry the case. This is what I was saying in the other video. It's not like you present your evidence, the other side presents their evidence, right? And then you go ahead and if you don't like the decision, you go, God, these guys are idiots, man. I'm going to go ahead and present my case to the U.S. Court of Appeals. They're not interested in going ahead and doing that. What they're going to do is they're going to look not at the facts of the case, but the process. Were you denied some sort of rights? Did you want to present something to the judge or the jury and the judge said you couldn't? Did the judge give instructions to the jury that you think tainted their thinking and made them think that you were more likely to be guilty? They'll go ahead and they'll examine the process, but not the facts in the case. Those have already been decided. And if they think that your process, like due process, was denied, if they think that you were treated in a way where your rights weren't protected, then they'll go ahead and they may go ahead and reverse the decision. We'll talk about the things that they can do. But they'll hear the case and they'll either decide whether the lower courts did it right or whether they did it wrong. Now, in a case like that, usually, like most cases end at the district level, at the federal district court. You get whatever happens there, usually it's done. But if you're lucky enough to make it to the next level up, to the U.S. Court of Appeals, most of the time, that's done. If they make a decision, then basically that's completely done. Their decisions are almost always final. But if you don't like what happens in the U.S. Court of Appeals, you can appeal to the United States Supreme Court. But here's the thing to keep in mind. In terms of the U.S. Supreme Court, they get, I think on average, around 6,000 applications for cases that people want to be heard in the courts. On average, each year, they hear 200 cases. So just because somebody wants to have their case heard in the Supreme Court doesn't necessarily mean it's going to be. As a matter of fact, the odds are it's not going to be. Only a few cases make it to the Supreme Court. And as I said before, once the Supreme Court makes its decision, that's final. There's no other appeal past that point. So next I'm going to talk about the power of judicial review, but I'm going to put it in the next video, and that would be Judiciary, I believe, Judiciary 03. And then I'm going to try and I have to do this backwards, so let's turn this off. And I'm trying to click on this, but I never know which one's the right button. So stop. There we go.